Okay, good morning everybody. So this is the last torts lecture. Hopefully it is your very last torts lecture ever. There may be some people who have enjoyed it so much that you want to come back next year, but there will not be a lecture tomorrow. So our plan for today is that firstly we're going to finish off the liability of public bodies. And then I have some kind of summary slides which we're going to go through of my material. And then I'm going to give you 10 minutes to do the set evaluations, which I know are a real pain, but we'd really appreciate you completing them. And then I have some other slides just on general discussion about, studying, preparing for the exam, etc. Although I know that this isn't your first rodeo, so you will be pretty familiar and have well-established study techniques and how to approach the exam. So the first thing, let's just remind ourselves, we really ripped through public body liability last week. So remember, we have this framework that we consider with claims and negligence against public bodies when identifying whether or not the public body owed a duty of care to a private party. So the first question is the claim justiciable? Can the court get involved in this claim? Once that inquiry has been satisfied, then you turn to the ordinary internal and external inquiries to establish a duty of care. So those internal inquiries comprise of the reasonable foreseeability test and proximity. If you're dealing with an omission, then it's necessary to find one of those special circumstances that apply, so that there has been an assumption of responsibility, or that there is control and proximity, or that the public body has some special kind of role. That one doesn't come up so much, to be honest. The real focus of the cases we've been looking at have been control and proximity and assumption of responsibility. And then you look to the external inquiries, and some of the external policy issues that can come up with public bodies that don't come up with private parties include things like the statutory context under which the public body operates. And courts will look to see whether, for starters, is there an immunity in that statute? Because if there is an immunity, that will defeat the claim, and that is exactly what happened in Strathboss. Okay, but even aside from whether or not there's an immunity, the question will then be, is a duty of care owed to a private party in this context consistent with the statute under which the public body operates? Okay, so that is always a key question. And then there are other inquiries that can come up with regard to public bodies, like, will this have a chilling effect on the services that this public body provides to the public generally, such that recognising a duty of care would not be in the public interest? Now, that is not a consideration that comes up in a claim against a private party, okay, because private parties don't act for the benefit of the public like public bodies do. So we then went through and we looked at different cases, okay? And remember in that we did that comparison between looking at whether there had been an assumption of responsibility, and we did that comparison between capital and counties, which was the fire service case, and the court looked at who does this benefit. Putting out a fire benefits the community as a whole because fires spread, so there is not this assumption of responsibility to the person whose property is on fire. And we compared that to Kent and Griffiths, where the ambulance didn't arrive on time. And when an ambulance is called, that benefits the person who the ambulance has been called for, okay? The person who is having some kind of medical emergency. And there was an assumption of responsibility in that case. Following that, we then considered some other cases, okay? So we looked at Robinson, and Robinson was that case when the police knocked the frail old lady over, and it was very clear here, the court said, look, if the duty of care is owed by a private party, then it will be owed by a public body, okay? So if you positively, by your positive act, cause physical injury, that is an established way that is an established duty of care situation. They did emphasise, however, that public bodies are often acting in stressful circumstances. Okay, so courts are not going to impose unrealistically demanding standards of care on public bodies. And so sometimes we will see that a duty of care is recognised, but it might be difficult to establish breach because courts will take into account the stressful circumstances in which some public bodies, particularly emergency responders, are operating. Then we discussed Tyndall. The key takeout of Tyndall was this idea of the interference principle being a way of making things worse. That interference principle was set out on a slide. It's all about if A knows or ought to know that B is in need of help to avoid some harm, and A knows or ought to know that they have done something to put off or prevent someone else helping B, then A owes B a duty to take reasonable steps to give B the help they need. So if you interfere with someone else helping, you know this, you know you've interfered, then a duty of care will be established on those grounds. And then we moved into other cases involving the police, including Hill and Michael and Jane Doe. Hill and Michael, no duty of care was established. And then in Jane Doe, a duty of care was established. And Michael, there was a real inquiry into, well, you know, the question of had there been an assumption of responsibility. The answer was no, based on the context of the phone call, when the call handler simply said, we'll pass the call on. They didn't assume responsibility. There was no control or proximity there. And then in Jane Doe, however, which arguably involved less proximity than Michael, a duty of care was found, but that was based almost entirely on this inquiry as to the specific risk the victim was under, without the associated inquiry that is necessary for omissions as to whether or not the third-party wrongdoer was under the control of the defendant police. Okay, so we talked about that. It was a wider understanding of a duty of care, and we talked about the kind of the issues around that, you know, the fact that they didn't really turn their attention to this idea of control makes it of questionable precedential value. Then we moved on to a couple of New Zealand cases, Couch and Strathboss. In Couch, they really focused on this idea of control and specific vulnerability. Those two important relationships between the defendant and the wrongdoer needs to be one of control. And that idea of control doesn't mean custody. Supervision was enough. Being able to determine where the bell worked was enough. So this was quite a, you know, the New Zealand courts were kind of taking a more open approach to control here than what we've seen in the UK. And this idea of specific vulnerability that the plaintiff needs to show that they are under as compared to the public generally. And after that, we talked about Strathboss. And again, that was a really good example of the kind of framework that the courts go through in considering a claim against a public body. And again, there was this idea that control existed because the MAF could control what came in and out of the country. They didn't need to have the actual pathogen in their physical control. The fact that they could control by means of, deciding what was allowed in and what was allowed out and the conditions on which they were allowed in and out, that was enough. But in that case, there was no duty, both because of the statutory immunity and because the external inquiries and the risk of indeterminacy went against other things like resource allocation, bottlenecking goods at import, all these other external considerations. The court said we wouldn't recognise a duty of care here. So there's a statutory immunity. If there wasn't a statutory immunity, it would satisfy the internal inquiries for a duty of care, but it wouldn't satisfy the external inquiries. Okay, so in that case there was no duty of care owed. And then we moved on to social welfare, welfare organisations. So the first case we discussed was Poole. That was the case involving the Poole Borough Council acting as a landlord and providing social housing. And there was a family put next to a very, how were they described in the case? Just some neighbours that were very, very problematic. And the court said, look, landlords are not responsible for the behaviours of their tenants, and no duty of care was owed for the antisocial behaviour of Surrey County Council's tenants in one property for the way it affected their tenants in another property. And then where we left it on Friday, so I will now turn on the slides. Where we left it on Friday, we were talking about HXA and Surrey County Council. So we're going to finish this, then we're going to compare it to an older New Zealand case, then we are just going to kind of bring public bodies together, and then we will be done. So HXA and Surrey County Council. We have HXA who had a terrible childhood involving neglect and abuse, and they were on the care register of local authorities. The neglect and abuse was from HXA's mother and mother's partner. The local authorities intended to undertake this full assessment with a view to initiating care proceedings, but it just did not happen. Okay, and HXA was never taken out of her mother's care. Eventually she left home. Eventually her mother and her mother's partner were jailed for the abuse. And the other case involved YXA, who was a young boy with epilepsy and learning disabilities and autism spectrum disorder, and the local council had concerns about his parents' ability to care for him. The local doctor had said, look, we think he's being over-medicated and he was being smacked, etc., and recommended that this boy should be taken into care. Eventually a pattern of respite care was established, one for, just kind of one night a fortnight and one weekend every 8 weeks. But that was it. And later he was taken into full-time care. And even during this period of respite care, the over-medication from his parents and smacking continued. So each of these claimed against the county council for the abuse they suffered while in their parents' care, saying that the local authority had assumed responsibility to look after them. This was a strikeout application, and both claims were unsuccessful. So, the court in these cases considered the governing statute. That's what you do with public bodies. And the statute itself was the Children Act, and it was neutral. So it didn't exclude a common law duty of care, but the court said we cannot build a common law duty of care on the fact that the local authority had statutory duties towards and powers in respect of the claimants. So what this means is that you actually just need to look at what are the actual interactions that have taken place between HXA, YXA and the local authority, who they are saying has assumed a responsibility here. And in this case, because what the claim was essentially that the local authority had failed to confer a benefit on them, they had failed to take them into care, they'd failed to protect them from the harm being perpetrated on them by their parents, they needed to establish an assumption of responsibility. Okay, to get this proximity for an omission, you need to fall within one of these special circumstances. The applicable circumstance the court was focusing on here was the assumption of responsibility. And they said, well, there wasn't an assumption of responsibility. So for HXA, the court said, well, yes, the local authority carried out an initial investigation, and yes, they resolved to undertake a full assessment, but they never actually did that full assessment. And they said this initial investigation is not a service to the child. That initial investigation is to enable the local authority to decide whether to bring care proceedings. It is not an assumption of responsibility to the child. We'll revisit that in a minute. For w6l, they said that the assumption of responsibility flowed from the pattern of respite care. So there had been this established respite care, and they said because of this respite care that had been established, they had generally assumed responsibility to protect this child from his abuse from his parents. And the court said no, the abuse was from his parents, not from those looking after him in respite care. They said that yes, there was a more limited assumption of responsibility during the period that w6l was with the foster parent. So when the respite care was actively happening, there was an assumption of responsibility, but that was not the relevant assumption of responsibility the claimant needed to establish this duty of care to protect him from his parents. And they said, well, when would there be an assumption of responsibility? And they said, well, so they provided some examples. And they said, look, if the local authority has actually obtained a care order and taken children into care, that would involve an assumption of responsibility, and that local authority would then be liable for any harm that came to the children while they were in that care arrangement, with this care being provided by a third party. And they said that could also apply in the absence of an actual care order throughout a pattern of respite care. So during those periods that respite care is in place, there is an assumption of responsibility to make sure those care providers are not, to protect the child from any harm being caused to them by those care providers. Now, and they said, look, in cases like this, so there are two things I want to say about this. So in cases like this where you can show that a child has been taken into care, they said it would not be necessary to show reliance. Okay, so you know how we've mentioned the assumption of responsibility, and in cases of negligent misstatement, it is essential to show reliance to establish this duty of care. They said in a case like this, involving a child being looked after by a third, a counsel coming in to look after a child, it would not be necessary to show reliance. And it would be kind of inappropriate to insist on it. Now, so it's kind of an example of, I think I mentioned at the beginning, that outside negligent misstatement, sometimes reliance is insisted on and sometimes it is not. Okay, so when you have a child, they say, well, it's actually pretty hard to show actual reliance here. And so the courts would not insist on it to establish a duty of care. But there might be other cases where reliance is necessary. Sometimes it will fall into causation. The key thing to take out of this is understanding that the absence of reliance in the case of an omission not involving a negligent misstatement may not be fatal to a claim. Okay, that's the key thing. And then it's all a case of kind of drawing analogies. What is this similar to? What is it not similar to? What have been the outcomes in those cases? But the court said that merely investigating what is going on in the child's home life is not an assumption of responsibility to protect that child from harm. Now, I don't know if you guys have any thoughts about this. Like, when I see this case, I think this is crazy. It seems like if you stop short of doing a proper job, you don't owe a duty of care. But as soon as you do the proper job and do the investigation that's required, you do owe a duty of care, the public body. So I'm not sure I like this case at all. I don't think it sits right with me that a duty of care was not established in a case where there was a clear grounds for a full investigation to happen, it didn't happen, and because it didn't happen, there was no duty of care owed. Does anyone else have a view on this? Yes?
I think the New Zealand case has a much better approach.
Yes. Yeah, the next case we're about to discuss. Yeah. Yeah. Okay, so we will compare this to a New Zealand case, which has a different approach. So this is a 1998 case from the Court of Appeal. The previous case that we've just talked about was a 2023 case from the UK Supreme Court. Okay, so we've got this kind of, you know, it's kind of been the story of my lectures, is that we have these diverging approaches. Like the cases look to each other, like you see New Zealand cases look to the UK cases. UK cases do cite New Zealand cases. You know, Couch comes up a bit in the UK. But there is a more liberal approach, I would say, in New Zealand to duties of care generally and against public bodies. So Attorney General and Prince. This involved two claims by an adopted man and his biological mother against the Department of Social Welfare. And he was neglected by his adoptive parents, had a terrible childhood, ended up in prison. Now, he brought a claim against the Department of Social Welfare. So there were two claims brought. The first claim was brought by he was now an adult, but the adopted child and his biological mother against the Department of Social Welfare for negligence in relation to preparing reports for the adoption court approving the adoptive parents to be his parents. Now here, the statutory context went against a duty of care. Okay, so it wasn't that there was an immunity in the statute, but there was a specific statutory process in place for closed stranger adoptions at the time. And as part of this process, the court received a range of information from a number of different parties, and based on that information, they made their own decision as to whether to approve the adoption. The report from the social worker is just one piece of information in a pile of information, and it is not accorded any primacy by the court in deciding whether or not to grant the adoption order. So this meant causation would be very speculative. Okay, it's very hard to show that this report had any material impact on the ultimate adoption order that had been made decades previously. But there was also this concern that a common law duty of care would undermine the intended finality of the adoption. So the Adoption Act itself didn't contemplate any kind of performance appraisal process that looked at how is this child's upbringing going, how is his well-being, is he happy, etc. It was a final thing. Once the adoption order was made, that was it. Now, there were some very deliberately narrow remedies in the statute that could provide a path to remediation, but recognising a broad common law duty of care on behalf of the Social Welfare Agency in relation to the report they carried out would cut across these narrow remedies. So it was felt that a common law duty of care was inconsistent with the statutory context, both because of the narrow remedies in the statute itself and because the statute contemplated a kind of like a process that didn't involve a performance appraisal. And recognising a duty of care implied that a performance appraisal was essentially going to be carried out to be able to assess whether or not the Social Welfare Agency had been negligent in preparing their report or not. Now, the second claim involved the failure of the Department of Social Welfare to respond adequately or at all to concerns that were raised with them by the neighbour of the child. Okay, so she called up when he was 14 to say that neither of his adoptive parents were looking after Mr. Prince or were prepared to look after him, and he was living on the streets. He had to look after himself. Now, in contrast with the first claim, recognising a duty of care here was considered to be consistent with the statutory context in which the Social Welfare Department was acting in relation to dealing with concerns raised about the welfare of children. So we're no longer under the Adoption Act, we're now under the Children and Young Persons Act 1974, and that was proactive legislation, the purpose of which was to protect children at risk of abuse. So if someone has called up to say, I am concerned that my neighbour's child is not being looked after, this is consistent. Recognising a duty of care to follow through with those investigations is consistent with the purpose of that statute. And the court also placed some emphasis here on the fact that the complaint was phrased as a failure to respond adequately or at all, and thought, well, this indicated that maybe this isn't just an omission, maybe there's an operational failure here, and because this was a strikeout application, and they said we need to have a sharp focus on the facts proved at trial. This is that, having a proper full trial here rather than striking it out is the more appropriate means of determining whether there should be a duty of care. But they did consider the internal inquiries under this idea of an assumption of responsibility. And they said, well, okay, first of all, internal inquiries. Reasonable foreseeability. Yes, it's reasonably foreseeable that failing to consider complaints that a young person is being neglected might cause harm to that young person. So that's that initial reasonable foreseeability screening test. Okay, and then we move on to the proximity inquiry. Was there proximity between the Department of Social Welfare doing this public service of looking after children at risk of neglect and Mr. Prince to support a duty of care? And in considering this question, the court looked at, other governmental agencies who discharge statutory functions and note that they are often performing professional tasks where a duty of care is recognised. Okay, so a doctor working for the public health system is providing a public service, but they owe a duty of care to their patient. They're performing a professional task, and the court said there is a professional relationship between the social worker and the child. Children and young people are vulnerable because of their youth and immaturity. They cannot assert their own rights and needs. Others must do it for them. And then they went on to say that when a Department of Social Welfare is exercising its statutory powers in relation to a particular child, they assume responsibility for that child. So, this is a strikeout. The court is refusing to strike it out. They want more information about what has happened here. But what they are saying is that once statutory powers are being exercised in relation to a child, there is an assumption of responsibility. Now, one of the questions you might have is, well, what does it take to establish that statutory powers are being exercised? If we look back to that HXA case, just an initial investigation, does that mean statutory powers are being exercised? Or do you actually need to take them into care? So there's a little bit of uncertainty around what it takes, but certainly the court was not prepared to strike it out in this case, and it seemed that less had been done than what had occurred in HXA. Okay, so we can get this general impression that the courts are more willing to find, particularly in relation to children, that there will be a duty of care owed by a Department of Social Welfare in a situation like this. They also turned their mind to reliance. Okay, reliance comes up when you're dealing with assumption of responsibility. They said, look, while a child might have no particular expectation that they will be helped by the department, in this case, Mr. Prince didn't know that the neighbour had called social welfare. So it's hard to show that he had actually relied on them in the traditional way. But they said, due to the community expectations reflected in the statute, so this neighbour would have thought, well, I've done my job here. I've let the department know that this child needs to be looked after. They said it's not unreasonable to conclude that a child or young person will implicitly rely on the department and its officers to consider complaints that they are in need. So essentially there was no need to show actual reliance. This idea that the system was relied on to do its job was enough. Now, this was a 1998 case, okay, and there was this idea, reliance was seen as quite important here, but I wonder if the same case came before the courts again, if they might be a bit more relaxed about reliance, if they might look to some of this UK Supreme Court jurisprudence that recognise that with children, maybe it's not appropriate to insist on reliance and stop trying to force a position of reliance before establishing a duty of care. Then they went to consider external inquiries, and they said, look, the Act was the starting point. The purpose of the Act was to provide for the care and protection of children at risk. That statutory scheme didn't lead inevitably to a common law duty of care, but it was consistent with it, okay? So it's not inevitable that there will be a duty of care because of the statute, but the statute was consistent with a duty of care, so it didn't rule it out. Then they said, look, the delicacy of the social worker's task is relevant, okay? It's a difficult balancing act that involves the interests of the child, the advantages in not disrupting family environment, the advantages and disadvantages of alternative care arrangements. Because of all these nuances in the job of a social worker, it is going to be difficult to establish breach, okay? It is going to be difficult to establish that the assessment made by the social worker fell outside the bounds sanctioned by professional opinion. Okay, these are not black and white calls. There's all these factors that come into making the call. But they said that does not absolve social workers of responsibility of considering and responding to specific complaints with professional skill and care. Okay, so they're flagging here, just because it's hard to establish breach doesn't mean we're not going to recognise that there's a duty of care, but breach will always be a bit of a hurdle. Another issue raised was defensive practices. So this question of, well, if duty of care, will this lead to a defensive approach to duties whereby, I don't know, maybe there'd be kind of overkill in terms of taking children away from parents, but the court did not like this argument at all. They said social workers are professionals just like lawyers, just like doctors. They should be expected to have shouldered willingly a standard of reasonable skill and care, just like their private counterparts are expected to discharge. And they said, yes, there will be difficulty showing causation and damage, but that does not rule out the claim for negligence at a strikeout stage. So we will leave that there with Attorney General and Prince. And if we were to draw it all together, we can see the sense that New Zealand courts are more willing, more open to finding that a public body will owe a common law duty of care to an individual than the UK courts. Usually claims against public bodies, not always, but usually they involve claims for an omission, for a failure to confer a benefit, or for the liability of a third party. And so to satisfy the internal inquiry for a duty of care, it's necessary to show reasonable foreseeability of harm, and either, now this is where you're dealing with the omission or this third party act, either that the public body is in control of the third party or the danger, and that the claimant was at special risk, or that there has been an assumption of responsibility. Even then, there might be particular policy factors that go against a finding of a duty of care. And of course, you've also got to consider whether or not the duty of care is consistent with the statutory framework, whether the matter is justiciable. So final slide here. You know, we've seen that courts treat some public bodies differently to others when looking at the assumption of responsibility. You know, think about why do they do this? Think about that reason by analogy. Who are the services being provided to? Who are they benefiting? We know why the law is reluctant to impose duties to act on private parties. You know, we've talked about this, about these that's why pick on me argument and this kind of interference with a private party's autonomy. You know, how many of those reasons, though, apply to public bodies? I mean, often none of them. Why pick on you? Because you're a public body whose sole purpose it is to do this job. You don't actually have this kind of big scope of freedom to do what you want to do. You've been given a specific job, and that is what the claim relates to. But perhaps different reasons apply to public bodies. You know, there's some thought that, you know, the more extensive the protective scope provided by public bodies, the less inclined we are to regard tragedies as the result of ill fortune, and there's this desire to ascribe blame. And so there's this paradox that the more that states do, the more they take protective measures and try and protect the public, the greater the risk is that they will be criticised and sued for not doing more. And there are also other means by which public bodies can be held accountable for their mistakes. Okay, so there can be inquiries. Just because a common law duty of care to a private individual isn't recognised does not mean that the public body gets off scot-free to make the same mistakes again and again. Often there's a proper inquiry into the processes, and changes are made to make sure these parties, to make sure the public body operates better. And that kind of brings us to that fourth point, this question, well, should public funds that could be used to pay for improved public services for everyone be tied up fighting private law claims? Interesting fact, 2022 to the year from 2022 to 3, the NHS paid out $2.7 billion in responding to clinical negligence claims. Now, that is enough to fund 3 of NHS's largest hospitals. It's an interesting question, right? Like, maybe it would be better to fund those hospitals and take less pressure off the existing hospitals. It might reduce the negligence occurring in the first place. So it's this idea of how is this public money best spent. Equally, at the opposite side of any claim against a public body is someone who has suffered some kind of significant harm, who is seeking compensation. And then this other point we've talked about is even if a duty of care is recognised, perhaps breach can step in to control liability within reasonable grounds, to recognise that public bodies, particularly emergency responders, are often working in highly stressful situations. So that brings us to the end of public bodies. Do you want to take 2 minutes, and I'll just bring up some other slides, and we will then go through the revision, the summary slides that I have. Hi.
I emailed the newspapers on the weekends.
Oh,
Yeah,
what's your
from,
name?
Joe.
Oh,
Yeah.
Joe, okay, yeah. That's fine, actually.
Regarding the duty of care, so we have the 2 step-by-steps, right? And then we have special cases like negligent misstatement that
Yes.
comes up in public
Yeah.
liability. Are there like extra hurdles you have to get through, or is it just like extra considerations?
So, hopefully my summary slides will make this really clear for you that I'm about to go through. But essentially, for negligent misstatement, to show proximity, you need to show an assumption of responsibility. Okay, so what proximity looks like changes a little bit if you're dealing with one of these special cases. If you're dealing with an omission to show proximity, you need to show an assumption of responsibility or imputed proximity. Yeah, so it's the proximity step that basically becomes more, it's an extra hurdle for some of those more difficult cases where the courts are less willing to recognise a duty of care. Yeah.
So it's basically like amending the step one.
Yes, so it's always reasonable foreseeability, it's always proximity, but what proximity requires can differ if you're dealing with one of these special cases. Yeah.
And also regarding the foreseeability, so we need foreseeability and duty of care, and the result is there's also a foreseeability requirement, so what's the difference between the two foreseeability?
It's the same idea of foreseeability. One obviously, one is it reasonably foreseeable that this type of harm is suffered? It's probably the same question you're asking. Yeah.
But I just don't understand why we need to relitigate it.
Yeah. Sometimes, it's a good question. It shows that you understand raise it, but some people say, yeah, exactly, say the same issues raised as well. Hi.
The position of the right was that in New Zealand, the position might be it's discretionary, it could become discretionary and it's not.
Yeah, I think what we would say is the court seemed pretty willing to find reliance on behalf of Mr. Prince, even though he didn't even know what the phone call, so it's hard to show that he actually relied on it. They were prepared to find reliance there. They looked implicitly that they would not. But now that even the UK Supreme Court is saying sometimes reliance is not required, it would not be appropriate to insist on it. Maybe they'll stop forcing it and just say reliance is not required for your children. We will recognise a duty of care and we won't defeat that duty of care because a child who didn't know what was happening on his behalf couldn't actively.
And for an adult, it would be different.
Maybe it would be different, yeah.
So in an exam when you say something like, in the past, it's pretty shown that reliance is required. The court seems to be more
into relax in certain circumstances where it feels inappropriate. For example, if it was a young child, dealing with a young child here, because we're not dealing with a young child, maybe they would insist. So you're essentially pointing out.
So we wouldn't need to make a finding on it.
You don't need to make a finding. You've got to point out, and you might point out the direction that, because this is more similar to this kind of case, maybe the court will go down this direction.
Thanks so much.
Okay, so some hopefully useful summary slides. All of my lectures have really focused on the duty of care and negligence for specific applied problems. Okay, we started off with pure economic loss. And what we saw with New Zealand cases is that with pure economic loss, unlike the UK, they tend to approach the duty of care question in the same way as all negligence claims, and they treat the fact the loss suffered as economic as one factor relevant to whether a duty of care will exist. Okay, so we've got our internal inquiries of reasonable foreseeability and proximity, and we have our external inquiries that cast the gaze wider to policy issues. Some of the specific policy issues that arise include indeterminacy, reasonable alternative means of protection, statutory context, whether or not the principles of contract would be undermined. Okay, so that's the general approach for pure economic loss. But the first week we spent on negligent misstatement. And in that type of case, an assumption of responsibility is required to satisfy the internal inquiries. Okay? Also, a different approach will be taken for relational economic loss. So, generally they approach it the same way and think, oh, but it's economic, so we'll take that into account. But if it's a negligent misstatement, they're like, oh no, we're going to require an assumption of responsibility. If it's relational economic loss, they're going to require something more as well. So, negligent misstatement. It's necessary to show that the defendant has assumed responsibility to the claimant to satisfy the internal inquiries. So what does an assumption of responsibility look like? The defendant foresees or ought to foresee the plaintiff will reasonably place reliance on the defendant in dealing with the matter. So this requires these two things. We need to have mutuality between the parties, okay? So is it the defendant who is given the impression that they can be relied on? And the case we looked at for this was that Williams and Natural Life Health Foods. And did the defendant know that the information they were giving would be communicated to the claimant? And it was part of his purpose in supplying it, that it would be communicated and relied on by the claimant. Okay, so we looked at that Banca Nazionale case for that. That also came up in some of those New Zealand cases like Boyd, Knight and Purdue. You'll have to go back to the slides. I haven't summarised the entire thing here, but this is to give you a broad picture. So you've got mutuality between the parties, and you need to show the claimant's reliance was reasonable. So what do we do to show this? Carter and AG had those 4 questions we pulled out, okay? So there needs to be an alignment of the purpose for which the defendant made the statement and the purpose for which the claimant relied on it. So if someone makes a statement to say a boat is seaworthy to keep people safe and someone relies on it for economic purposes in valuing the boat, there is not alignment. There will not be an assumption of responsibility. And there needs to be an alignment of the persons for whose benefit the statement is made, and the plaintiff needs to fall within that class. And oh my gosh, I'm having a mind blank as to the name of the cases, but we had a case where maybe it was Caparo, where the financial reports were made just for shareholders to exercise their general management of the company rights, and someone relied on it to make a big and takeover bid and buy out the company. The people who relied on it were not within the class of those for whom the statement was made. Then you need to show actual reliance. And in Boyd, Knight and Purdue, that was the case where there was no actual reliance, okay? That was the case involving an auditor's report that said these accounts are true and fair when they weren't, but the people who relied on it didn't even read the accounts before making their investment. And so there had been no reliance. The statement that the accounts are true and fair was absolutely meaningless unless you read the accounts to find out what position it is that is true and fair. Is it a position of prosperity? Is it a position of poverty? Other things that will go towards reasonable reliance. Does the defendant have some kind of special skill that makes them reasonable to rely on? If I tell you to invest in something, would it be reasonable to rely on that? No. Why? Because I have no special skill in what makes a good investment. Has the statement been made on a social occasion? If so, that will be a factor that goes against an assumption of responsibility. Okay, the courts are less willing to impose duties of care in social interactions. Is there a disclaimer? Has the person who made the statement said, this is my view, but I disclaim all responsibility? If so, reliance will not be reasonable. That is exactly what happened in Headley Burn. So that is negligent misstatement. Relational economic loss. The approach is uncertain. Okay, there are some old High Court cases in New Zealand that have adopted the known plaintiff rule from Australia. The High Court in Strathboss, more recently, noted more the Canadian approach in Bow Valley. Okay, so it's a bit of an uncertain picture. And so what we pretty much have to do is look abroad. Now, if New Zealand was going to go down the path of the UK, they'd rule out relational economic loss. Okay, but that seems unlikely because we don't seem to take the UK approach towards duties of care and negligence. The rest of the negligence inquiry might be more aligned, but for duties of care, we're more liberal than the UK. Australia allows recovery where there is a known plaintiff. Okay, so you look at those cases and say, well, is it a known plaintiff here? If New Zealand was to adopt the Australian approach, what would happen? Canada excludes recovery for relational economic loss unless the claimant can fall within one of the three exceptions. Okay, general average, joint venture, and you need to kind of work out, well, what does a joint venture require? You know, like what, and that's not certain, okay? We have those two different pictures that were drawn out in the Canadian case law we discussed about what would be required for a joint venture. It is an uncertain picture. Understanding the difference between them is helpful. Is there a possessory or a proprietary interest in the property? And they have also left the door open for a new category, a new exception where the courts would be willing to recognise a duty of care for relational economic loss, but they were pretty, the door was only very slightly ajar. They're not seeking to push anyone through it. It would need to be pretty compelling, and they identified some specific policy factors that needed to be present. All of this was covered in the slides that we dealt with for relational economic loss. Okay, so then we moved on to omissions and the duty of care. First question, are you dealing with an act or are you dealing with an omission? Has the defendant made it worse, or have they just failed to confer a benefit? And then we had that kind of picture of liability, that picture of a duty of care. Okay, liability also requires breach, causation, damage. But for the duty of care, okay, there's not normally a duty of care for a danger we have not created unless special circumstances exist. Okay, what are those special circumstances? Assumption of responsibility by taking on a task for the claimant's welfare. The defendant's status is holding an office or position of responsibility. This could be like the owner or occupier of land, parent, employer, etc. Or the defendant has sufficient control over the dangerous thing, which could include a third party, and there is reasonable foreseeability of harm to the plaintiff and a particular risk of harm to the plaintiff as opposed to the public generally from that dangerous thing. Okay, so that deals with dangers we have not created. We are likely liable for dangers. We do owe duties of care for dangers we have created, including dangers resulting from human agency. So that can be those third-party cases like leaving a horse untethered in the street, who might just bolt if a child throws stones at it, or if someone knocks over a big pile of crates and makes a loud noise and gives the horse a fright, etc. Have you created a danger? There will be liability resulting from it. And that can also include the interference principle from Tyndall. Finally, today we have talked about public body liability and the duty of care. First question, is the matter justiciable? The courts will not get involved in second-guessing policy decisions or discretionary decisions of public bodies. But provided you're outside that and it's operational, the courts will be willing to look into it. Is a duty of care owed? Internal inquiries, you need to show reasonable foreseeability and proximity. Is it a positive act that has caused damage, like in Robinson? Internal inquiries are straightforward. Is it an omission or a liability for a third-party act that is being alleged? Then we go through that same approach, which I won't read out because you'll be getting sick of the sound of my voice saying the same thing over and over again. Okay, and then we have external inquiries. Now, some of those specific policy factors that arise with public bodies include the statutory context. Is the duty of care compatible with the statute that governs the public body? Is there an immunity in it? Would it otherwise be inconsistent with the statute or consistent with it? You know, we saw cases like Prince where part of the claim was inconsistent with the statute. There wasn't an immunity, but it was inconsistent with the statute. Cases like Strathboss where there was an immunity that was fatal to the claim. Another question, would imposition of liability make public bodies more cautious and defensive in carrying out their actions? Now, this is something that comes up with public bodies because that will affect the benefit the public body has to the public generally. Would it result in a reallocation of resources that would not benefit the public? Or was the plaintiff particularly vulnerable to harm here? Which can arise, for instance, in Prince and Attorney General. So they are my kind of summary slides, but obviously we have discussed in detail the cases that go to each of these points. This just kind of pulls it together for you. So so 2 more things I want to do. Can you take 10 minutes to please do the set evaluations now? Might only be 5 minutes. Sorry, I know these are a pain and they come at the worst time of year, but what we are particularly interested in is, you know, your views on like the workshops were new this year. What did you think of the workshops? Did you like them? Did you like having an assessment as part of them? Did you like that assessment being, you know, group work kind of being encouraged as part of the assessment? Would you have preferred it to have been more a case of do it yourself? If you want to talk to your friends about it, you can, but not actively encouraging it? I don't know. I'm just interested to know how you felt about it. And then we had a test this year. Previously we've had an essay, but we've gone with a test. And then, of course, the moot and the final exam. So we're really interested to know kind of constructive feedback around that sort of thing. Hi. What's that? Oh, okay.
I just had a question, sorry, about curriculum across.
Yes.
You said the sort of the approach differs from negligent statement and relational economic loss. For consequential loss then and surgeon practice.
So consequential loss is straightforward because all you like the goal of consequential loss is prove the property damage. You get the consequential loss, that's reasonably consistent.
So just the North Shore and inquiry is to
Exactly.
foreseeable impact.
Yeah. Yeah. And for those sui generis cases, well, in New Zealand we kind of saw each time they just did the ANZ inquiry, you know, well, and then the defective building thing on its own level, where essentially the established positions and duty of care is owed. So you wouldn't even need to go through that inquiry because you just cite the case and say, well, duty of care is owed.
And that was the same for the wills and tests.
For the wills, exactly. But what was interesting about those wills cases was exactly the reasoning that our court looked at, kind of broader inquiry as opposed to the UK, which seemed a bit more robust, particularly.
So sort of just citing those cases.
Yes, that's enough for established duties of care. So you only need to go through this for like non-duties of care.
Be a case because in the defective laws,
Yeah.
where the New Zealand position was there will be duty of care for residential and non-residential buildings.
Yeah.
For the local authority, they've done the full price of the time
Yeah.
under the station.
Yeah.
There was that point about the dangerousness in the Australian and the UK
Yeah,
positions.
I mean, yes, so that has not been relevant to New Zealand. So that they like, we don't care if it's dangerous or not. Yeah. Yeah, and you know, sometimes when I'm lecturing, you know, obviously, so when you're practicing in New Zealand, you know the approach, but if you were to go and practice in the UK, it's quite useful to understand.
Just there were the relational economic loss and the other ones we is sort of relevant because the
Yes.
position New Zealand is not confirmed,
Yes.
but it is confirmed in New Zealand.
Yeah, for the building, it is. Yeah.
And then what was that? There was that third class of surgeon risk claims.
Oh, that was Spring. There was just that one on case, Spring and Guardian Assurance, which was the reference case.
Oh yeah.
Yeah.
And is that the same thing? You just cite.
Yeah, exactly. You'd cite it and say, yeah, I think you would just cite that case and say, look, this has been recognised in Spring. That would be of no compelling value in New Zealand, potentially, particularly given that it was a rare case in the UK finding a duty of care outside of such a responsibility, and we know New Zealand's quite important budgets. Yeah.
And then the last thing is that first step that appears in a lot of different cases.
Yeah.
That foreseeability
reason it's always relevant is that if you cannot foresee harm being caused by your actions, how do you know to change care? How do you know to change how you're acting to take care?
Is it always determined?
Well, it's the initial screening test, so if you can't get through that, yeah, it fails. Yeah. Although you would never, obviously, in an exam question say, I mean, you've got to have something to say.
And then I actually missed that lecture on justice here.
On
the
justice
state-
ability.
What is
Oh,
that?
yeah.
Okay, I'll do
So
that.
so it's all about is it operational or is it? Well, I mean it's a really kind of complicated one, but essentially the courts are going to get involved and start questioning how a public body has allocated its resources and decisions I've made, for instance, about we're going to use this type of canister to attack certain situations. That is what involved. That's for the public body, it's got specialist expertise who knows how it needs to allocate its funds, what it needs to do, blah, blah, blah. But having made those decisions, how they implement those in practice, the court will get involved. So there was an example about the, I can't remember.
The flammable.
Yeah, the flammable one. I think it was rugby maybe. Anyway. So, yes, exactly. So they weren't questioning that it was wrong to use those canisters at all, but they said, but using it without fire, that was that's right. Okay, how is everyone going? Are you almost through them? Do you want another 5 minutes? Just nod your head if you do. Yep, cool. Okay. If you've got any questions, you're welcome to come up and ask while you are doing them.
Excuse me, I'm just wondering because like I went to the Chinese law talk workshop yesterday, and they said that based on the 2024 exam paper, which is called CAS, they had preparations and a question about whether or not there should be common law actions in privacy and the negligence question. So what I'm wondering is that going to be, is everything a semester or just semester 2?
Semester 2.
So there'll be a question on negligence, one on relation to economic loss and purity.
I'm not telling you what you've got a question on, but it's only semester 2. So the material Joe and I have covered only. Okay, so that's what you need to be aware of. So the first semester is not being covered in the exams.
Just run through negligence.
Just go through all the material. Yeah.
I just wanted to confirm one thing,
Yeah.
which is even in New Zealand, despite the council specific if you have a public body and you're only providing for like operations, you still need to fit it into one of the 4 categories, so like extreme circumstances,
Yeah. Yes. Well, sorry. Well, firstly, what you've got to do is work out what are you dealing with, like what category is it. So if they have created a danger, then exactly, or a positive it's straightforward. Okay, but if you're dealing with exactly, you've got to look at the facts and say, well, hold on, what is this? Is this a blatant omission? Is this someone trying to pin liability on the third party on the public body for the acting third party? If it is that, is it because they have particular harm? Is it because they've created the danger that the public body is stuck? So you've just got to identify what are we dealing with in this special scenario.
We have that additional element. Does that completely replace proximity? You establish that you don't need
Sexual responsibility. You always need reason to prove it.
yes.
is the assumption of responsibility which requires the idea of reason. Well, you've got to go through those cases we're talking about. So if your economic loss that falls outside relation to economic loss, we follow some things that falls outside the economic loss. We talked about some specific examples. Okay, so we talked about all the cases, we talked about fraud cases, and then we talked about spring and barriers, okay, the ways that those are used. Yeah.
It's about the emissions framework.
Yeah.
Just say, if you have an emission, public body, you have one of those three circumstances. Let's say you establish one of the three circumstances. That means that your proximity assessment is nothing else.
Yeah, that's right.
Replacing it.
No, that's right. So, I mean, you know, sometimes it might not be clear that one is meant to be out there, so it's not another one. It's just really important that many assessments, that's what many assessments.
So if you find that, say, the public body owes an emission and then you found that
There wasn't something responsible.
there wasn't a function of responsibility, that's proximity factor.
Yeah, that's proximity. Yeah. And then you go to
On the
external factors.
in an exam scenario, it would be worth it to consider, say, the control proximity. So
Yeah, you would treat, yeah, I mean, I always think that's,
yeah.
yeah. If the question lends itself to it. Yeah. I mean, when you're arguing in court, you know, you're not going to put all your eggs in one basket, are you? Yeah. Cool. Okay. Right. Let's carry on. Has everyone done the set evaluations? Thank you very much for that. Appreciate that. Okay, so general revision slides. Just about preparing for the exam. I mean, look, I know this will be like, you know, oh God, we know how to do this. But anyway, you know, go through and review your lecture notes. You know, if you're unclear on issues, go back to the cases, read them, read the text, flesh out the area. And then condense your notes into something usable. So, you know, as you all know, you can only, you can't use any notes on your computer in the exam. You can only bring in hard copy notes. You will not be able to move away from the Inspira exam thing to access any other notes that you've stored on your hard drive. So you need to bring them in a hard copy. And, you know, you're not going to have time to kind of read through and be like, oh, yeah, what's this negligence thing all about? Like, you know, think about, know the material, know what you're looking for. And, you know, the best way to prepare for exams is to go through problem questions and to start establishing in your own mind the framework that you're going to apply to the different problem questions, and then have those mental headings of I need to think about this, I need to think about that, I need to think about that, this is what I'm looking for, these are the cases, etc. You know, get a group together, go through exams together, that's always helpful. I actually think it's quite helpful to give yourself not just trying to exam questions in a really limited time frame, like give yourself as much time as you need. Save the limited time frame until when you're actually in the exam, rather than doing everything and not giving yourself the time to think through the issues. My hot tip is please don't use old notes from Notebank. Lecturers change. You know, I've never lectured half these areas before that I've been lecturing this year, so the areas focused on change. The law changes. There are new cases. There will be questions that lecturers will write wanting you to pull out something of a case that might not have been previously lectured. And it will be very obvious to the lecturer who is marking your exam if you've just gone, I'll just use these notes from someone else. You know, like you will be missing some issues. So that is my hot tip. Engage with the material that we have taught. And so work out how much time you have for each question and stick to it, and just move on once time is up. It's always easier to get the first marks in a question than it is to get the final marks, the last marks. You can always go back at the end if you've got time, but don't throw all your eggs into one basket and answer one question really well and not deal with another question, because you are just capping your marks in a way you don't need to. So with problem questions, read the question thoroughly. You know, read the question at the end so you know what you're at the start. Go to the end and think, what is the question? And then read the facts so that you know what's jumping out, what's relevant for when you're reading it. What are you looking out for? Identify the issues and what torts are raised. devote the most time to the most significant issues, less time to lesser issues. You know, don't write everything you know. Because it's open book, because you get to take your notes in, we assume your notes are accurate and give you marks for how you apply the law to the facts. You know, how you are drawing analogies to the cases to make to reason through your answer. That's how you get the good marks. Don't discuss non-issues. Yes, so think in advance, get yourself a framework or a structure for how you're going to approach the different sorts of questions. There's no right template. Make sure you're answering the question that you're asked. Don't go and give a full exodus on liability generally if you're just asked to deal with causation, or if you're just asked to deal with standard of care, or if you're just asked to deal with duty. So read the question and answer the question you are asked. It's fine to, so application, I feel like this is very repetitive. Application is the key. Analogical reasoning, applying and distinguishing, authorities that we've talked about to the facts you're given is key. Don't only raise the facts of the authority if you're using them for a purpose. Don't just explain a case and then just move on. Like, why is this case relevant? What are you drawing on this case that makes it relevant to this question? And it's fine, you don't need to write out full case names. So if you're talking about Alcock, you just do Alcock, underline it, whatever it is. You don't need to write out the entire case name. It's time wasted, provided the person marking knows the case you're referring to, and that it's clearly identifiable, then that is all you need to do. You don't need to have the kind of full citation or anything. It's different to a moot, obviously, when you are making an argument for a client. Okay, here you are advising a client and they want to know what, advising someone, should they bring a claim or not? So they want it balanced, like where are the pressure points? What are the points that they might not get through, and focus your attention on why that is a concern for their claim. Set out your reasons fully. The reasons will be more important than a conclusion, but do reach a conclusion. Avoid things like, well, if the court decides this. I mean, that's just not, say it's, the law favours this, or based on this analogical reasoning and this comparison, I think this will be successful or not successful, etc. If it's unsettled, you can deal with that. We don't need to deal with essay-type questions because you've been told you have problem questions to deal with. Bring your laptop. Bring a hard copy of any notes you want to rely on, because you cannot access notes that are on your computer. This is incredibly repetitive. So yes, you don't have time to rifle through thousands of pages. Skip to the time. So what you'll have is 2 hours and 30 minutes, and that includes any time spent dealing with technological issues. They have this 30-minute buffer for technological issues. So if you do have technological issues, you don't get extra time. If you don't have technological issues, and most people don't have technological issues, lucky you get 2 hours and 30 minutes to work on the exam. You're not restricted in that extra 30 minutes. It is individual work, so you cannot discuss it with anyone, okay? It's in an invigilated room, it's on a closed browser, it's individual work. Oh, I've put there are 3 questions. This is from last year and I haven't amended it. There are 2 questions. Okay, so question 1 is worth 50 marks. It's a problem question with multiple subparts. You have to answer each subpart. Okay, you might need to click through the pages to answer each subpart. So you spend half your time on question 1 and spend half your time on question 2, which is another problem question with multiple subparts, and you'll need to click through it. Examinable material is just the material taught by Joe and I in semester 2. Okay, that's all we're going to say. I'm not going to tell you what part of it. It is just semester 2 that is examinable. And that's all. So I have office hours tomorrow from 9 till 10. We have workshops on Thursday and Friday, so make sure you attend a workshop. They're not recorded, okay? But they're definitely worth attending. Joe and I will both have office hours next Wednesday from 9:30 to 1. We sit a couple of doors away from each other in building 803. I'm in room 318. She might be 316 or something. So come and see us with any queries, but that will be the last opportunity. Your exam's the following day. After those office hours, we won't be responding to queries or emails after that time. You've been a really great class. Actually, we've all really enjoyed teaching you, so thank you for that, and good luck. And that's all. We can finish early.
through the day. It's just sitting in the lecture theatre waiting for, luckily the theatre's empty. I've got to get through a lecture from 11 to 12, and then I've got my Maori course from 2 to 4. But that's pretty passive, so I'll just sit through that. No, it's best. Yeah. Not feeling like $1 million. That's what it is. There you go. I forgot Sammy's got had his walk today as well. Still want to get home like 4:30, 4:45. I'm going to have to take him to the pet shop. Yeah. Yeah, okay. Love you too. Thanks, son. Bye.